Welcome to the Well Off Podcast, where the goal is to motivate, inspire, and share success principles. I'm your host, George Almasri. On this episode, I interviewed Glenn Gosling from Caveat LLP. He's a paralegal, and I've personally worked with him on a few different matters with tenants. So on this episode, we talked about N4 notices, which is for non-payment of rent. We talked about N8s, which is for persistently late payments. We talked about N5s, which is, I guess he called it a catch-all for various issues, including, let's say you have a tenant that isn't complying with bed bug treatment, so preparing their unit for that sort of thing. How effective is it to file an N5 in that situation? We talked about N10s to increase rent more than the allowed amount. And if you were, let's say, doing improvements to the unit, you were improving the kitchen, adding new flooring, that sort of thing, and the tenant agrees to pay you a higher rent, is that actually legal and allowed? So I think for anyone listening that has rental properties, there's going to be some really good information for you. There's a lot of questions around what's allowed and what isn't allowed, landlord rights and that sort of thing. So I think you're going to enjoy this episode. And if you do, make sure to share it with someone who's going to benefit from the information, and leave us a review on the platform that you're listening on. That would be greatly appreciated. And finally, if you are interested in Southern Ontario, the Golden Horseshoe, and you're looking to get into multi-units, 5+ units, I'd be happy to help you out with that. So I am a realtor. I can definitely help you with representing you on that front, but also I can help you with off-market opportunities that I have, and just general advice if you'd like to pick my brain on anything there. So feel free to reach out to me on Instagram, welloffx, or by going to welloff.ca. You can find my contact information there as well. Enjoy the episode. This episode was brought to you by Mortgage Dawn with Go Pineapple. All right, I'm here with Glenn. Glenn, thank you for joining me.
Oh, no problem at all. A pleasure to come down.
Yep. Your childhood. Where'd you grow up? Obviously, you have an accent, so you didn't grow up here, I'm assuming. Where did you grow up, and a couple things you remember?
Well, funny enough, I'm from here. The accent is false. No, it's not. I was actually born in Etobicoke.
Oh, yeah?
Quite a few years ago, kind of thing. My father was a police officer and unfortunately was killed while he was on duty many years ago. We traveled a lot. And then landed back where my parents were originally from UK. So I spent many years in the UK. I did most of my education and my university education there.
Where in the UK?
Liverpool, not far from.
Okay.
Yeah, so I went to the University of Liverpool. I was in healthcare prior to going into law. Yep. Or providing legal services. It was a big passion of mine. Still remains a passion, and I think that's where the let's try something new comes in, basically. It still has the roots of advocacy, but it's just advocating for a different party these days. So as healthcare was getting more difficult, I found you were have to advocate more for patient care and healthcare providers and everything like that. So my natural progression was to go into advocacy, and now I do a lot of health law, but also our office and most of our clients focus on landlord and tenant law, and that's where it's landed me. So I've been back in Canada since 2003.
When did you get involved in law and become a paralegal?
So yeah, I was working in a leadership role in healthcare, and I was finding myself getting in more and more arguments with senior management, basically, in regards to care that was provided or services that were provided. So I found myself to be relatively good as an advocate because I was always in trouble. So going over to law or legal services basically gave me the opportunity to argue instead of getting in trouble. Make a career out of it. So I made the leap and left my leadership role back in 2016 and 2015, sorry. And then I finished my training in 2017, and I've been working as a paralegal ever since.
Got it.
Yeah.
Okay, let's dive into this because there's a lot to touch on here. We've got N4s, N8s, N12s, N13s, the portal. Why don't we touch on the portal first? So for anyone listening, what is the portal, and is it a good thing or a bad thing?
That's a good question. So the portal is the step forward when COVID happened, as many people may know or remember, that landlord and tenant board essentially shut down and never came back to in person. They started on Zoom and they've remained on Zoom. So it was a natural progression for them to move away from faxes and emailing applications in, or walking into the office and having this portal. The justice systems had this for quite a few years, and it's been quite successful. So the LTB took a crack at it. And initially, it was very limited to what you could use it for and what you couldn't use it for. So there was a mix of people emailing stuff in, faxing stuff in, using this portal. And it's now gone to around, I would say around 90-95% now on portal. What is the portal? Portal is a way that a party, whether it's a landlord or it's a tenant, can start an application, basically. So they go onto the portal, they fill in their application. If it's a landlord and it requires a notice that we'll talk about shortly, then obviously that notice needs to be given. But essentially, when you're filing with the LTB, this is what you use this portal for. It will give you a file number, which normally starts with LTB and followed by T, which means it's a tenant application, or an L, which means it's a landlord. There's a load of numbers, and then there's a dash, and then there's two numbers. The ones that you will see now is 23. And basically what it's telling you is the year it was filed, which is more prevalently useful these days than it ever once was. We're still dealing with dash 19s, dash 20s, dash 21s. So, the odd dash 23 does get heard, but essentially it's a backlog. So has it cleared the backlog? No, it hasn't. Has it made it easier for parties to file an application? Absolutely. And it's also an opportunity to share information. So when it comes to disclosure, you can do this as long as you've got permission to the other side to use the portal. So, and then the last piece I'd probably like to say about the portal as well, it gives you an option to connect with one of the dispute resolution officers. So ordinarily or historically, you would have to wait for your day in court, basically, to speak to one of the dispute resolution officers or mediators, as they go by both names, to come with a resolution. Wasn't an issue, pre-COVID. You were waiting 6 weeks for a hearing, so it really wasn't an issue. Now you're waiting 7-8 months. I would say this is the most useful part of the portal itself, that if you and the tenant can come up to some kind of agreement, even if it's a payment plan or whether it's within an 8 persistent late rent, and you can come to terms, you can, as long as once you filed that application, have a virtual communication between you, the tenant, and a dispute resolution officer, basically, to come up with terms of an agreement. And now dispute resolution officers have been given more power as such, or more ability to write orders that are on consent, so they're able to resolve this issue sooner than later. So if you have good terms, or you're in good terms with your tenant potentially, and there's a way of maybe resolving this out, whether it means attaching a Section 78 to a thing, and I'll talk about Section 78 in a minute, then it might be better to get that up and going, and at least you have that. And then if there's a breach, then there is a more expedited way to move towards eviction then, because you've taken that first step of resolution. And that is all done through the portal as well. But to be part of the portal, and if you're completing your own application, and the most important thing that you should do if you don't include it is your tenant's information. More importantly, their email address within the application itself, if you've been using it, because then they will be given access to the portal, given a PIN number, and they'll be able to communicate that. So if you don't include the tenant's email address, then the LTB will deal with it old-fashioned and mail out the information, where if they're on the portal, then they have instant access to the information, and as do you.
Yeah. All right, so just for anyone listening, if they filed an N4 for non-payment of rent, then it's the time period passes where the tenant has the right to pay what they owe, which is typically 14 days after, plus potentially a few days if you're mailing it or whatnot. let's say that time passes and they still haven't paid, then the next step is an L1 at that point, correct?
That's correct.
And then would that L1 be filed through the portal? Let's assume if a tenant is a landlord is doing it on their own behalf and not represented by a paralegal. So that's where the portal kind of comes in handy, where the landlord could just file this type of stuff online.
Absolutely, yeah. And just make sure that you spend time reading the instructions. So there's twofold in that. Yes, you can do your L1 application and many applications online through the portal. Two, if you go and even do a Google search and you go LTB forms, there are it will take you to the Landlord-Tenant website. It has two things. One, on the left-hand side, it will have the form itself, and on the right is the instructions for that.
But like the N forms, you can't file through the portal, correct?
No. So, an N, which is a notice, is not an application.
Right.
It's simply what it is. It's a notice, basically. It needs to be part of the litigation process, and it needs to be uploaded to the portal to demonstrate that it has been provided. But essentially, the tool that is used is the application in support of the notice.
Sure.
At the litigation process.
Okay, so let's go through this. Let's say somebody files an N4, the tenant owes for that 1 month, and then next thing you file the L1, you're waiting for a hearing date. 7 months pass, tenant hasn't paid a dime. You get to a hearing, and let's just say, just for this example's sake, they owe $10,000. When you get to the hearing, at that point, let's say the tenant's represented and the representative says, well, we want to go on a payment plan to repay the $10,000 that we owe. What would happen in that scenario if you're representing the landlord? Do you have to accept that, or do you have other options?
No, there's other options, but at the end of the day, you're now in a point where is it reasonable, right? So yourself as a landlord or your representative should make an argument why if you're not accepting of that payment plan, because that payment plan has to be consented by both sides. So it can't be just like the best I can do is $20 a month, right? No, that's not going to work out, because that's a payment plan for potentially 5 years or 6 years on top of your regular rent while you're paying. So it has to be something that's reasonable. And what I do with our clients as landlords, I try to look at a 12-month plan, or even sometimes even an 18-month plan. And I'll tell you why. Because if you get a payment plan, it takes the wind out of them appealing or the next step. Were you reasonable? Did you offer a payment plan? But with that payment plan, you want to tie that payment plan to, again, a Section 78, which some people may call a penny or a day, or people might say last chance, basically, where going forward, they're agreeing not only to pay their rent in full on time, which is generally the first of each month, but then maybe 2 days later or 2 weeks later, or even on the same day, that there's going to be an additional payment made with those arrears, unless, for argument's sake, call it $250 or $300 a month, right? So essentially now they're paying $1,300 a month.
Right. So in this case, let's say they owe their regular rent on the first of the month, and let's say you agree on the 15th of the month, they're going to pay an additional $200 or whatever.
Yeah.
So if they're late on their rent payment for the first of the month, you can apply that Section 78, or does that only apply to the repayment plan that you've agreed on?
Well, it depends on what you ask the adjudicator or the decision maker or the dispute resolution officer and what's agreed upon, kind of thing. So if you go in front of the adjudicator, you can ask for it, and the adjudicator may give the Section 78 to not only, and what they will do and likely will do, and they do this with most orders, but you have to ask for it, that you want a Section 78 attached to not only the repayment section, but the regular payment.
Right.
And that will be held until the arrears are paid off. So that's why I mentioned before about maybe payment plans that might go into 18 months. Well, you then have a hold over your tenant to be in line, basically. So for 18 months, because that payment plan is 18 months, if they're late a penny or a day on either payment, then it's very likely that they're going to get evicted within the next couple of months, basically, if they breach that order.
Yeah. Okay. If you don't agree to a payment plan, the tenant owes 10,000. They've given you a hard time for months and months, and you don't want to deal with them anymore. You just want them out. You want to ideally collect the money that's owed to you. Is that an option, or will the adjudicator say, no, they're offering a payment plan that's reasonable, you have to go for it?
Well, you can ask for anything you want, but it depends on whether you get it. So is the landlord right to saying, no, we've, this arrears of rent arrears has been building up over the last 10 months. He has not made any effort. We've reached out to the tenant basically and asked for a payment plan prior to today, and only today that they come to us with a payment plan. We believe it's unreasonable. We think the payment plan that they're offering is too low. It would take too long. And then the adjudicator may ask some kind of probing questions about where you are financially, and why it would be put the landlord in, a financial hard position if to accept this kind of thing, and that the better option would be go for the eviction. So again, it goes on the behavior of the tenant. If you raise these issues, in other words, around the payment, or, here's 6 months of text messages that I sent to the tenant, asking for a payment plan or assistant with a payment plan. As you can see, no response, right? All of these things can be used and to show the pattern of behavior from the tenant, and it has to be disclosed at the hearing within the disclosing period of 7 days prior to it. And these are the things that an adjudicator will take in consideration.
Yeah.
To say whether eviction, payment plan, or nothing at all. But you definitely need to give that information to that adjudicator to make that
sure
that we're going for eviction only. Now, they may overrule, but,
So let's just say you had a scenario where a tenant's not paying rent because they feel like the unit is not up to par for whatever reason.
Yep.
They don't have adequate heating. They have flooding issues. There is other maintenance issues, that sort of thing. How would that be perceived by an adjudicator? Would they potentially waive any amount owed because of these issues, or do they look at it differently?
So they'd look at it differently. So really, when it comes down to paying rent, there's no reason why a tenant should not pay rent, even if it's major issues, opposed from vital services. We'll separate what vital services are versus maintenance issues. So major maintenance issues, that gives the tenant the opportunity. What they should do is stop paying rent to the landlord, but they have to pay into the board. So there's an application out there, an N4 and an L1's been done, and then the tenant comes back and says there is a big long of issues of maintenance issues. So until these are sorted out, what they should do is be paying into the board. So then if you go to the board, you're successful, you can get that money straight away, or a portion of it. And why I say a portion of it is, let's say some of the maintenance issues have got some water, hold some water, right? Then an adjudicator should not, and I've not heard it, but the LTB is such a crazy place lately that you never know what you're going to get with this. But they should never come back and say, no, that rent arrears is completely wiped out, and we're starting from fresh, basically. What they may come down to is a rent abatement up to and maybe including 20% of a monthly rent for the number of months that may happen, basically. So what may happen if the tenant that was actually paying into that they'll release the rent that's owed to you if they've made a determination that there are maintenance issues that should have been dealt with and weren't not dealt with. They may hold a percentage back. Basically.
So let's just give an example. Let's say the rent was $1,000 a month.
Yep.
Just to keep it simple, the tenant didn't pay rent for 10 months.
Right.
Because the toilet kept backing up.
Right.
And they were frustrated about that, and the landlord didn't address that issue right away. For example, And then the adjudicator might say, well, we're going to do an abatement of 20%. So let's say $2,000 for those 10 months. And now the tenant only owes you $8,000 for this. Something like that.
That's correct.
Yeah.
So that could happen. So a scenario like that, and I think this is an interesting point to raise. So you raised some maintenance issues, and absolutely right. A tenant can do that during an L1 application, but generally they're not allowed to bring up maintenance issues for other applications. So, and they try to, N12s and 13. I know, but I've got all these issues, right? Well, they have availability as well as landlords to file their own application for maintenance. And we as representatives will, when it's tried to be raised by a tenant, if it's not an L1, we will push back and say, no, this is not the time or place to do it. They have their own remedy. The L1 is the only application that I'm aware of that a tenant can bring up maintenance issues as part of the rationale for the arrears, but no other application.
Yeah, you mentioned vital services.
Yes.
What would that be considered? Obviously, heat is vital.
Yes.
I'm assuming access to water.
Yes.
So if they don't have, for whatever reason, access to water within their unit, then that's
right.
vital. What would be some other examples?
No, I think you more or less covered it. It's the big ticket items, right? Is there water, is there electricity, is there heat? Sometimes cooling, if it's an exceptionally hot summer and everything. But these are the things that if you have to be very cautious of, because if there is issues with those vital services and they are not up and running by the day of the hearing, there's a possibility that the tenant or the tenant representative can ask the adjudicator to dismiss the whole application because there is a vital error made or by the landlord by not up maintaining the vital services. And we've actually seen that happen. So, and you could wait 7-8 months and the water could be off, or one of these vital services may not be there on the day of hearing.
But how do you prove that? Like, let's say it's a heat issue.
Yeah.
And the tenant says, no, I didn't pay because I don't have adequate heat in my unit. Well, what do you have to do? Like, do I just take pictures of the heat source? Let's say it's baseboard heaters. Do I film a video of it working? And I don't know. How do you prove that it's actually working?
Right. So one, if you're getting the bills, you'll see. Two, you absolutely should be getting, if someone is saying there's something wrong with their unit, and I get there's tenants that will call you for everything, but the big ticket items, these are the ones that you should definitely listen to. These are the ones that if you think it's a possibility, and I'm like, there's absolutely no way, the whole heating system was replaced last year. There's no way it's broken. I'll just take I'll pop down and just make sure it is working.
You just log it, right? Like I log on this date. I inspected the baseboard heaters and they were working.
That's right.
Here are photos of
And if it's a vital service like that, I would be bringing in my contractor basically to say, attended on this date and everything.
Yeah.
And respond back to the email or respond back to the text, keep hold of it, because you're gonna have to demonstrate to the board that not only did you respond, you responded back in a reasonable amount of time. What you were offering was reasonable. We've had tenants who will say, oh, this is not working, that's not working. And I'm like, okay, no problem. Speak to the landlord. Landlord turns up with their contractor, gives 24 hours notice. And guess what? Surprise, surprise, the tenant refuses entry. Right? Because, so if you've got a true problem, you're going to let someone in that house, right? If you're not, then you're just biding time.
Yeah.
Right? And if that's the case, that's when you hit them with an N5, basically. Refuse entry, right? Behavior of the tenant.
Right. That's another thing we should talk about. Actually, that's a perfect segue. So I think we covered quite a bit. Actually, one more thing on the enforce. Let's say you have a tenant that has a cosigner or a guarantor. They don't have money. They blew all the money. They didn't pay rent, but they blew it on whatever they spent their money on. But you have a guarantor or a cosigner on the lease.
Yes.
You can target that person at the L1 hearing, I guess, for the arrears.
For those of you who are looking for the best interest rates, it's worth noting that interest rates do have their seasonalities. Usually during the spring and fall time, we're in what we call the hot real estate market, where we're seeing a lot of real estate transactions. And this is where lenders will want to take market share. So they do want to become as competitive on interest rates as possible. Outside of that, you may also follow the bond yields for fixed rates. If it's going up or down, usually this will have a direct impact on the fixed rates. I would love to connect with you for all your mortgage-related questions. You can reach me at 647-961-3281, or you can find me on Instagram and Facebook at The Mortgage Dawn.
Yes, so they become financially responsible because they've signed off for that for the year, for the fixed term year. And what generally doesn't happen is most people just flip over to month. Well, that guarantor does not. The liability of the guarantor does not flip over when you go at the end of your 12 months fixed term and go into a month to month.
Oh, really?
Yeah,
the guarantor is off the
guarantor is off the hook.
But the cosigner is not?
Well, guarantor and cosigner, I'm classifying them as the same thing because they're the person that is financially responsible if the tenant doesn't pay.
But isn't a cosigner named as a tenant on the lease?
No, because they're not. And some people do this. I had a client ask me about this. And, well, no, because you don't want to give them rights as a tenant. You want the guarantor to carry the liability, but not carry the rights of a tenant. You put them on the lease as a tenant, then they're not a guarantor.
But let's just say that this person doesn't live at the property. They own their home. They live there, and they have a child that's moving into one of your properties.
Yep.
They just put their name down on the lease, but they never actually live in the place. You're still saying it's better to have them as a guarantor.
Yes. Because they're not living there, they're not a tenant.
But theoretically, if you have them in that scenario as a cosigner, as a tenant on the lease, they would be liable for arrears even after the first year has passed, even when it's month to month, or no?
If they're listed as a tenant, not an occupant, then they're held liable for that. But if they can demonstrate that they were never a tenant, a fancy litigator could flip that round and say they don't have any responsibilities of being a tenant except for covering the tenant's rent if they didn't pay.
Right. I had no idea it only covers 1 year. That's pretty crazy.
Yeah, because it flips over, right? So it flips on the same terms, but smarter people than I have said basically after that year when it flips into that natural month to month. Now, if you want them held for another year, then you get them to sign another lease and sign off their accountability.
Can you attach a schedule or something that states that you will be a guarantor for the life of the lease while this tenant is in the unit or something like that?
I think that would be a difficult clause to put into a legal document because what lawyers really like is clear start, clear end dates. No, just as long as it goes, basically. So I would, and also you don't know what the situation is 10 years down the line or 20 years down the line, maybe for a legacy client that they don't know. So what the law looks at is, was it clear? Was it made very clear to that person what they were signing? Because they're not a lawyer, right? They're not a lawyer, and you're writing the contract and passing a contract to them. You will hold the liability of being transparent, clear, concise, basically. So if they don't understand that, they'll the law will actually blame you as the writer, right? Sure. So just make it clear, make it concise, and every year do a refresh, right?
So theoretically, if you said something like you're a guarantor for 2 years or 3 years, then that might be better than
as long as the tenancy goes on, right?
Yeah.
Then what happens if 3 years into it, then they're not, right? But they are. But
yeah. If you feel like,
how do you chase dreams?
Sure. If you feel like the tenant isn't going to stay for 10 years, they've told you I'm just here for a bit, saving money to buy a house.
Yep.
Maybe you just put you're a guarantor for 3 years. Perfect. Then you're okay.
Yeah, you should be. But remember, you should be reviewing. And I think this is where a lot of landlords miss the opportunity to bring up those responsibilities that a tenant has in the form of a signed document, basically, a refresher, that they don't renew. They just flip into the month to month, and then other things get slipped with month to month. More importantly, not increasing your rent, big fault for a bit of our big clients where they'll take over buildings and, the rent hasn't been increased for 15 years. Right? And suddenly now they need, 30, 40% to get their bottom line. You're not going to get that.
Sure.
Right? So always this, if it means spending 10, 15 minutes each year, basically renewing your agreements and increasing your rent, like make it part of your routine, new lease, it has to be the same terms. It's because you're writing a new lease doesn't mean you can change, the terms. It doesn't mean your rent can go up $1,000 or, whatever it is. But you're just getting everyone on the same page, everyone signing off. So again, that reasonableness, when you go back to an adjudicator and you can say this person's, been a guarantor for the last 3 years. Well, how do they know that? Well, because every year I made sure that they sign new documentation and we're fully aware of it. Oh, well, the adjudicator has nothing to go back on you to that.
Okay. And speaking of rent increases, so I'm not going to get into the basics because we've touched on stuff like this in the past, but let's just say you have somebody that wants a new kitchen or new flooring done in the unit, new appliances.
Yes.
And they're paying $700 a month.
Right.
You say, well, okay, I'll happily buy you brand new appliances and spruce up the kitchen and this and that, but the new rent will be $1,100 a month. And the tenant agrees to that. And everybody's on the same page. Everybody signs off and you have everything documented. Would that be a legal new lease, monthly lease amount? Or can the tenant go and say, no, this is illegal. I want my rent reduced back to $700 a month?
Well, they can do both. Which is the unfortunate bit. So you can use a form called an N10, which is basically you come to an agreement with your tenant that you're going to increase. Like, in other words, I'm just going to put new flooring down. We're going to increase your rent, more than 2.5%, but less than 9%, basically.
Okay.
And both parties can sign off on that. Within that year, an the tenant can go back to the board, because it is above the guidelines. So
9% on $700 is nothing.
Well, and that's 9% over potentially with an AGI over 3 years. So only a maximum of 3% per year for a maximum of 9. It is, and this is why it's very important to go back to basics. And I know you've covered a lot of the back to basics about how do you manage your tenant. Well, and I understand some people inherit tenants and inherit those problems, but increasing your rent, even though it's only 2.5, it's 2.5 this year, it's going to be 2.5 next year. They release that date, and then next year, I don't know. I have no idea. But, you're always going to be behind the weight, the cue ball, basically, if you're just relying on,
Yeah. So that example I said of the $700 a month increase to $1,100 a month, is that completely illegal?
If you both agree with it, it's fine. But within a year, because the legislation says that rent cannot be increased beyond, the regular amount, or if an AGI approved, then the adjudicator has to go back to what the legislation says. So it claws it back to probably 2.5%. Each adjudicator will probably make a different decision on this. But essentially within a year, which is the limitation period that anyone has to bring an application in front of the board, they can say, yes, I did agree, but I don't agree. Now, the defense would be, we have an N10, it was fully explained, it's fully lined out what the tenant's going to get for that additional money, and both parties were agreeable. So that type of argument may work, basically, as a defense to an increased N10.
Yeah.
But it also might not work. It's a risk. Bottom line, it's a risk.
Okay, fair enough. We touched on N5s, and then we kind of went back and forth on the other notices. Can you explain how an N5 is used, and also the success rate you've had with N5s with your clients?
So N5 can be used for a number of things, basically. But mainly it comes down to the rights of other tenants and whether that tenant is abusing that. the rights of the landlord and whether the tenant's abusing that, or the behavior of the tenant causing issues within the unit itself as well. So it's a, I'm not going to say it's a catch-all, but it is quite a large net that an N5 can be used for. So the success rate for me personally for N5s that leads to an eviction are quite low. And I think the rationale for that is because it depends on the behavior of the tenant, what happened. Sometimes it's smoking, sometimes it's just behavior. And what some people don't realize is, how do I get utilities if utilities are meant to be paid by the tenant, but they're not paying that. Some people would, some landlords were trying to put it into as part of rent, and it was getting kicked out because utilities and rent are different. How a landlord uses the money when it comes, whether it goes to utilities or whether it goes to rent, is up to the landlord. But you can't include unpaid utilities in a non-payment of rent. That has to go under an N5 because it's a breach of the right of the landlord for enjoyment of the property, which is basically now you're forking out for the bills. You can go after them using an N5 for non-payment of rent as well as behavior. So it's a very broad application. It only goes into the more specific things when it becomes illegal, like what they're doing is illegal. Then you up that. It's called an N6.
If it's illegal, they're selling drugs.
Correct. And it's reference to the Criminal Code of Canada. Yeah. So are they doing something that is in breach of the Criminal Code of Canada? If they are, not only are you getting the police involved, but that ups the ante. Basically, it changes to an N6 opposed to an N5.
Okay, let's go back to the N5 for a second. Let's say you have a fourplex.
Yeah.
And there's bed bugs.
Yes.
And you have a pest control company that's coming. They want to spray.
Yeah.
And they give the tenants a week ahead of time a list of things that they have to do in preparation for treatment. 3 of the tenants comply, follow all the steps. 1 tenant refuses. They don't do anything differently. So the treatment's ineffective because everybody has to follow. That's, I'm assuming, grounds for an N5. Do you think in that scenario the landlord would be potentially successful in evicting the tenant for that if this happens on more than one occasion? Let's say it takes 3, 4, 5 treatments and the tenant doesn't follow any of the steps.
It's possible. There's going to be no straight answers. Anyone gives you a straight answer in law these days or legal services.
Have you had success with this type of a situation in the past?
For like bed bugs and not preparation kind of thing?
Yeah.
I personally haven't had one of those cases. I know there's many cases like that out there. But yeah, absolutely. But when it comes down to it and you go to your hearing, you're not going to just say, we have bed bugs. We think it came from this unit and therefore, the whole building, and they didn't comply. You're going to have to show that ongoing behavior, right? Not just once. I gave 4 notices to come in, you refused, or I gave 4 notices for treatment, you didn't do it, right? So showing the non-responsiveness of the tenant. But if they're not responsive by email, then the board's going to expect you to go above and beyond because you're a landlord.
Well, what if the pest control company is documenting everything?
Yep, absolutely.
And they have photos, they have proof that they went in that day?
Absolutely.
Yeah.
Yep, absolutely. And I'm like, we went in, there's clothes everywhere, there's clothes all over the bed or whatever it is, or nothing's bagged or whatever it might need needed for that treatment. Absolutely, you're going to show this, but you're also then, when did you give notice? How long was it? Was it clear? Was it concise? Is there any way that possibly anyone may not understood what you said and what you needed to do so? If you can pass those barriers at the LTB and demonstrate that you did this very clear and concise way, and despite this, that the tenant gave no response, you still followed up, they gave no response, and it resulted in this, which resulted in more treatments and more issues,
more expenses for the landlord
because they're paying for multiple treatments. And now they're probably already dealing with tenant applications themselves from your other tenants who are saying, you are not dealing with the bed bug issue. You've had people come in all the time, and a week later, I'm still getting bed bugs.
And not to mention that if you do have vacant units, it's going to be very hard to fill because of this issue.
Of course. Yeah, of course.
Sure. Okay, so that's the only problem. I think you would know better than I do is that N5 applications are kind of at the bottom of the list, right? Like they take even longer than N4s to get a hearing date from what I've experienced.
So experience, this is all we can speak about when it comes to the LTB and waiting times is experience, and we've all got our horror stories, and they're all long. Mm-hmm. But do they prioritize one application over the other? I have no doubt that they do.
Yeah.
But I think that they're told different ways on how to prioritize on a daily basis.
Yeah, for sure.
Let's an old English saying of organizing a drinking session at a brewery. That they're just that disorganized, they couldn't even do that.
Yeah.
It's called something else, but
Yeah. Let's talk about N8s.
Yes.
So that's for a persistent late payment.
Yes.
Correct. How successful have you been with N8s?
I like N8s.
Okay, tell me your experiences with them.
So I find personally that N8s are stronger than most applications when you compare it to an N4. If you meet the threshold of an N8, then the tenant can't come back on that. Where in N4, for example, you can have up to $5,000-$6,000 in rent, and then suddenly just before the hearing, bang, they pay off the rent, or one of the rent banks pay off their rent. Your application's gone.
Yeah.
And
you got to restart.
And you got to restart again, and you got to wait for an. But with N8s, once you've met the threshold, you've met the threshold, right? So it's now up to the tenant. It's up to you to demonstrate at the hearing that they're persistently late, which is easy to do. And then the tenant has to give rationale why they were late, basically. One, that they have to admit that they are late, and then they have to understand why they are. If you can demonstrate that the landlord is going through very hard financial times, so like this, for example, the mortgage goes out on the 2nd of each month, the rent is due, this tenant never pays until the 4th and the 5th and says, I'm going to pay tomorrow, I'm going to pay tomorrow, I'm going to pay tomorrow. They never do, and then they end up, 10% of their, 10%, 20%, and then 50%, and, they just get into this pay you when they feel like on their terms.
Yeah.
No, we have to stop that, right? So yes, you're absolutely going to go into an N8 and say, because of the behavior and because of the financial hardship on the land, this is why we want and we're demanding a eviction. And a lot of the times you will get that. I personally find that if they're persistently late but running a kind of not clearing the arrears all the time and there's an ongoing thing, I think you've got more of a chance of getting the eviction than getting a Section 78 order, which is also, as long as everything's done correctly in front of the board, your default's going to fall back to a Section 78.
Yeah.
Now, the difference between a Section 78 for an N8 and an N4 is the N8 will be for a whole 12 months. So it puts your client in a line to pay on the 1st of each month full rent for 12 months.
Just to recap, a Section 78 is basically if the tenant is $1 short or a day late on rent, you kind of bypass the whole hearing and you just go straight to the sheriff, right?
Yes and no. Depends.
Okay.
So in theory, yes. So you have a Section 78 penny or a day, let's just call it that as well. And they're a penny or a day late kind of thing. If they breached an order, so you've gone and done your N8, and you've had your mediation or you've been in front of an adjudicator, you've asked for that thing, and you get that Section 78, right? And you get it for 12 months. Now it's a written order. It's a breach, and they've missed it. It's a breach of an order. So that's an L4, opposed from an agreement. If you did a payment plan and they agreed to it, it's an L3. But if you do a breach of an order, like they've upped the ante,
yep.
You can do an L4, which doesn't cost anything to file. And with an L3 and an L4, what the process is that within that application, you have to demonstrate your position that they breached on paper and paper alone. Right? What you're saying in the words on the page and what other things that you may support as evidence to show that they did not pay on that day. if you're successful with that, an adjudicator will look at it. Without a hearing, they will read the application, see all the evidence, and say, "Yep, they met the test," and they will write the eviction order. That should happen within around 30 days. Sometimes it's not. Sometimes it's longer. We all know that. But you will get that order. The other option for the adjudicator when they're reviewing that, let's say that you wrote all the dates that they missed, kind of thing. Or you said that they missed January and they missed February. They didn't pay in January or February. So therefore, or they didn't pay the full amount in those months. But you just say those words, but you don't demonstrate it. The other option an adjudicator can do is actually put it down for a hearing for that L4 application, basically, for you to orally make that argument in front of adjudicator with the tenant being there to argue against it.
Right.
So it can trip into a hearing, but if everything's done correctly and the board does what it does, you should have an order within 30 to 60 days, which is an order that you can go to the sheriff's office with on a certain date.
Okay.
And they'll set that date in the order.
Got it. So just to recap, N8s, you have within a 12-month period, a tenant pays on the second of the month, 5 out of the 12 months, let's say. Is that grounds for an N8, you think? Or you think that you're not really going to have a good chance?
So I think you've got a reasonable chance, but it is close to the wire. So, and a colleague of mine was, and again, this is where we see the diverse decision process of the LTB. And there's a reason for that, in my personal opinion, where you will get adjudicators who will agree with you that the second of each month is not the first of each month, and therefore this is bad. And you've done it 5 times, which is what the test is for an N8, and therefore you're getting your eviction. Good to go, right? You will get another adjudicator same day, different room, who will say, well, is the second reasonable?
Yeah.
How do you pay, right? Yeah. So do you pay by check? Do you pay by e-transfer? Do you pay by cash? And therefore, if you pay by check, is there a processing time that might be reasonable or not? Did the tenant give post-dated checks for 12 months and the landlord didn't, put it into the bank until Monday because it was a Sunday, right? Yeah. So that's why I say depend.
Sure. It always depends because every adjudicator has a different way of processing information and coming to a decision.
They do. The discretion of a decision maker at the tribunal is way too wide, in my personal opinion, for people who are not legally trained.
Sure.
And sometimes that's what you get at the board. And even in other tribunals where they are not so reliant on a sole adjudicator, that they will have 3 people there. They'll have a legal expert, they'll have a content specialist, and then they'll have a member of the public of good standing. And between the 3 of them, they'll make a decision. Yeah. But with the LTB, they don't have that. They put all that decision process in that one person. Now, that person can be a lawyer of 20 years who dealt with real estate law, knows the the ins and outs. Might be a paralegal who's been practicing, since 2012 or even before that, very experienced in landlord and tenant law, right? And now has become an adjudicator. You can get people who've been adjudicators for many years, and through those years they've gained experience, but not necessarily legally trained. Or you can get people who are brand new, never done anything in legal, or brand new coming out of law school or paralegal certificate, and within a couple of months they're sitting there being given the discretion to go left and right of the black and white of the law.
Right.
And that is why, in my personal opinion, why we see such a diverse decision process coming out of the LTB, because not all adjudicators are the same. Their experiences are not the same. And they're drawing from experience from their, whatever they may do in their day-to-day or the past life, and trying to apply it to the law.
Sure. Okay.
And sometimes it works well, and sometimes it works terribly.
Right. Yeah. Maybe just as a final thought here, do you feel like things are going to get better in terms of processing times, getting to a hearing date sooner, that sort of thing?
I think there's a capability of doing so, and I'm still struggling why the LTB haven't done that. So I don't know enough to know enough. I do know that they got a big investment from the Ontario government to improve things. from my perspective and my client's perspective and our office's perspective, whatever they're doing is not good enough. It's not good enough for anyone to wait that long and have no safety net for both parties while you're waiting a very long time, like longer than we sometimes see in regular courts for a dispute like this. Like there's, I think it gets worse, and I think people talk about affordable housing, and I think we've gone way too far to one side, and we've gone to extremes on the left and the right here, where nothing's going to get resolved. And what we're finding is that people who have investment properties don't want to be in Ontario anymore. They want to go somewhere else where the rules appear to be more balanced.
Right.
And if we lose the backbone of our landlords in Ontario, then I think you lose affordable housing in any shape or form. So, and the fear of politicians dealing with tent cities is not going to get better. It's just going to get worse.
Sure. Yeah. We covered a lot of ground. I appreciate your insight on all this and your experience and expertise. Do you feel like there's any final thoughts on your end? Anything you want to share? I don't know, anything that you've come across, any scenarios recently, anything that the listeners should know?
Yeah, okay. A couple of things. So again, I do a really good job of talking myself of, the office getting clients basically sometimes. Because sometimes I'm like, honestly, don't hire us to do this. Do this, but if you get to this stage, then you need representation. So, and I'll take a page of my experience of my previous life of healthcare, where prevention is better than cure. So everyone's dealing with the cure right now, and you're 4 or 5 months into rent arrears before you start the process, right? And now you're going to be 12 months of carrying that cost. So what things can you do to prevent that? Well, I know it must be exciting to get your investment property and start getting the investment to work for yourself. So, and that helps with getting tenants in. So spend some more time screening your tenants. There are services out there. I'm not going to advocate for one or the other, but there are services out there that will screen or assist with screening with tenants. And spend the time or spend a little bit of investment to reduce your risk of the person that's renting your property is not going to end up being a tenant that doesn't pay rent. So that would be my first bit of advice. 2, always try to talk to your tenant in a sense of what you're looking to achieve and not what your end result is. So, because if the minute you start talking about absolutes to the other side, they respond in the same way in absolutes. And then you get this extreme, and nothing gets resolved, and it makes it difficult to understand, to come to a resolution that both sides are unhappy with. In fact, you might be forced into a settlement that you're really unhappy with. So if you can start those negotiations early, it could prevent issues down the road. Each tenant's different, each landlord's different. So yeah, I would say that would be my second piece. Kind of spend more time screening. Attempt to, when you see the first sense of issues, try to resolve them rather than let them fester.
Yeah.
And when you're bringing these issues, bring the issues while you want them resolved, not that you're demanding for them to happen.
Yeah, I find, obviously you know more than I do, but sometimes landlords have a bit of an ego, and they take things personally. Like, the tenant hasn't paid, I want them to pay me back every dollar, whatever, that sort of thing, and that doesn't really work well. Like, I think it's better sometimes to just take a small loss and let the tenant go, even though they might owe you some money and that sort of thing. Just move on to the next one, clear that headache, and get somebody in there that's a better fit for the property.
Yeah, I would agree and disagree with that statement. So absolutely, you should try and work with your tenant as best you can. But where I I'm going to say not disagree, but where I have a difference of opinion, and each interaction is going to be different. You don't. You do want to give the inch sometimes to make it work, but make sure it doesn't become a power move by the tenant to go for the mile.
For sure.
Where then you're forever in this, what about now? What about now? Okay, I'm going to give you what you want. Okay, well, I want this now.
Yeah.
Right?
The tenant's going to always test to see how far can I push this landlord? How far can I take this?
So, for example, look, the payments have gone, maintaining this house is more expensive. So therefore, for us to maintain the bills, we're really looking forward to you paying on time. I need you to pay on time. So in other words, you can lay a foundation, but what can you do to help us achieve that goal, right? And if that means, at the end of the day, and again, you can get an agreement, right? If that means that you're going to split your rent into 2 payments, basically, because at the end of the month, you'll still have your payment. It might be worth doing that if your tenant's getting paid every 2 weeks, right? But you're going to say, okay, we'll do this, but this is, ordinarily we wouldn't do this. I'm going to do this to help you out, but you're gonna sign something to basically confirm that you're going to do this going forward, right? So,
okay, perfect.
Yeah.
That's great, Glenn. Do you maybe just want to share with people how they can get in touch with you? And that's probably ideal.
Oh, absolutely. So I'm one of the 3 partners at Caveat LLP. I work with 2 fantastic partners, Andrew Trebetto, which a lot of people who listen to this podcast know, and some people who may know, like me, might, like you said to me, I know your name, but I've never met you. We have another partner, Angie Smith. The 3 of us basically all work in the similar areas of law. So you can call our office or email us, and any one of us can give give advice and everything. Consults, especially for KW agents, are always free. And we would much further KW agents phone us and say, can I run this by you, rather than wait till it's a problem, than having to retain us. We'd rather give you 10 minutes free advice, so you don't have to retain us, and then you come to us when it's a major issue. And then we're going to be there to help you out.
Perfect. Glenn, I appreciate your time. I appreciate your insight, and I look forward to staying in touch.
Yeah, absolutely. Thanks very much for the opportunity to come down today. It's nice to leave the city of Hamilton. So,
thanks for listening to this episode of the Well Off Podcast. If you enjoy the show, then I'd really appreciate if you left us a review on iTunes and let us know your thoughts. In order for us to get a larger audience, it's really important to have reviews, so your support is extremely appreciated. And also, don't forget to share the podcast with your friends and family. Until next time, I'm George Almasri. Have a great day.